carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. Mr. Allen, are you ready for your closing argument?
Make sure we got this video working good.
All right.
Good morning, everyone. Thank you again for your service as jurors in this case and for your attentiveness over the course of the past week. The judge has just instructed you on the law to apply to the facts of this case, and there's a common theme running through many of those instructions. Use your common sense, apply reason, draw from your common knowledge, and rely on your life experience. While much of the testimony over the course of the past week has been from people in the medical field, EMT, doctors, a nurse, and pathologists, at its heart, this case comes down to applying common sense, reason, and experience as you evaluate the evidence that was presented to you. You first heard from the Cadens, Dave and Lisa. They told you about how they opened their home to the adoption of 6 children from China, in addition to their biological children. They also talked about the relationships they developed with the Berries, a trusting relationship born of similar spiritual interests and a shared experience in raising and parenting children with a trauma background. The Cadens trusted the Berries to provide respite care to one of their older daughters in 2014, so it should come as no surprise that they similarly trusted them with the care of their daughter Selah in 2018. That backstory was largely echoed by the testimony of Jesse and Lori Berry. And I think everyone is in agreement that Selah was not without her behavioral issues. Again, that's part of why she was brought back to Wisconsin in the Cadence time of need. They loved her and they wanted her to be safe. Selah had issues with food, with tantrums, with lying and stealing, all of which was expected at the time she came to live with the Berries. What she did not have was a history of self-injury. In roughly 4 years of counseling notes with Dana Horn, not one note was produced by the defense to dispute this. Was there some risk-taking behavior, some food behaviors, walking out of a window onto the roof to evade door chimes? There was. But all of that behavior had a purpose, an attention-seeking purpose, and was never with intent to self-injure. I think there's also general agreement that when Selah arrived, the Berries were given authority to address her medical needs through the power of attorney document that the Cadence had provided. That makes perfect sense. As Lori Berry testified, she was in the best position to know when Selah needed physical medical attention, much more so than the Cadence, who were hundreds of miles away attending to the needs of another daughter. Lori Berry also acknowledged that it would be better to err on the side of caution when it came to medical emergencies, and that if the roles were reversed, that she would want to be informed of any injuries to her child or increasingly problematic behaviors of her child, particularly if it was resulting in harm to the child. But that's not what happened here. There was again agreement that once Selah arrived, the plan was for her to drive communications with her parents. We went call by call through those communications. On occasion, there were tears and sadness, but for the most part, the calls were positive and upbeat. The Cadence missed Selah, and she missed them. Following the May 24th call, there was a period of radio silence during the week leading up to Selah's death. The Berries had told you this was because they didn't want to bother the Cadence, who were going through their other daughter's surgery preparations. But they also told you that Selah's new behavior of fake fainting was getting worse and worse in terms of severity and frequency. up to 15 times per day by the end. Think about that. That's almost a fake thing that's felt every hour of the day. They also claim she was starting to physically self-injure herself, hitting her head on stairs, tumbling downstairs. Yet no call was made to the cadence to inform them of this increasingly serious behavior until the afternoon of May 31st, after Selah had already been lying motionless on the floor for more than an hour and a half. We went through in detail the calls of that afternoon of May 31st. Lori Berry, who had some prior nursing training, and Alexis Berry were the eyes and ears of that afternoon for Dave and Lisa Caden. They were also the eyes and ears for Jessie Berry, who was previously a nurse. Lori and Alexis recounted how they believed that for nearly 4.5 hours, Selah's issues were simply behavioral. They told you about the things they did to make sure of this. Claimed to have checked her breathing, her pulse, her temperature, her color, even her capillary refill. This despite the fact that they believed this was all merely behavioral. And not once did either of them attempt a sternum rub, a brief 2-second rub of the chest that had immediately pulled Selah out of a similar fainting spell just 2 days prior. According to the Berrys, it wasn't until Jessie arrived home at around 4:30 that afternoon that they became concerned for Selah's physical health. But even he claimed she was breathing, she was warm, she had a heartbeat, she had a pulse, right up until the time EMS was called. You know what happened from there. EMS arrived within minutes, immediately noting that Selah was extremely cold to the touch. The fact that she was already dead was obvious to them. And Dr. Sharpswain noted during his testimony that Selah could have been pronounced dead at the scene, and no one would have thought anything of it, as his clinical impression was that she had already been dead for a few hours. Despite this, EMTs and hospital staff made every effort to revive Selah before she was pronounced dead at 5:25 p.m. the afternoon of May 31st. Something else was obvious to medical staff that afternoon: evidence of physical abuse of Selah. EMTs noticed the bruising to her chest and her upper body, as seen on this photograph. They also noted the shading and bruising to Selah's wrists. And they noticed bruising and marks to her neck. Dr. Berg in the emergency room documented this full range of injuries all over her body: arms, legs, knees, elbows, chest, neck, face. She noted this abuse in her medical note, including possible physical restraint, given symmetry of shadowing and abrasions at the neck, under the armpits, the wrists, and the hips, and the necklace-like distribution of shadowing and bruising on Selah's neck. Even the defense witnesses acknowledged they would have reported the evidence of abuse to law enforcement had they been treating Selah that day. Dr. Berg did not have the benefit of an internal examination to further inform her differential diagnosis, but at that point the body was turned over to Dr. Stewart for further examination. Now, in the meantime, law enforcement had begun its investigation. Detective Bowers spoke with Lori and Jessie Berry twice that evening and again later in September. She also spoke separately with Alexis Berry. To their credit, the Berrys have been cooperative, but their story has never added up with the physical evidence. At the same time Dr. Stewart began his autopsy on June 1st, additional law enforcement officers were at the Berry residence searching for evidence. Not much turned up. A few suspicious ropes and a blackjack that has been talked about extensively that could have been used as a weapon. I was very upfront with you about this. These objects were tested for DNA, and Selah's DNA was not found on those objects. nor were there any other weapons that were found and taken that would explain the patterned injuries observed on Sayla's body. And notwithstanding the defense witnesses' opinions about DNA evidence, you heard from Detective Bowers, and I think common sense informs you that DNA evidence would have been of limited value from that house. Sayla had lived with the Berries for roughly 5 weeks and had been in contact with Lori and Alexis throughout the day on May 31st. I'm sure the defense will claim the state cannot prove exactly what happened or who between Lori and Alexis Berry did what to Sayla Caden that afternoon. But that's because their version of events that day is the only version we've been given. And their story, again, does not add up with the physical evidence. What the state has shown beyond reasonable doubt, and what Dr. Steers testified to the required medical legal standard of more likely than not, is that Sayla Caden died of homicidal suffocation at the hands of multiple perpetrators. Dr. Steer went through the report of his examination, finding by finding and photo by photo. He detailed blunt trauma to the top of the head. The top of the head, not in the half-burn distribution as he talked about. He detailed multiple facial abrasions and bruises. Dr. Steer noted severe thoracic trauma, including pattern injuries, to both the front and back of Sayla Caden. He noted extensive contusion and abrasions to the buttocks, inconsistent with Sayla having fallen. Like Dr. Berg and the EMTs, he noted evidence of restraints about the wrist. And most importantly, Dr. Steer noted evidence of manual suffocation. Again, the acute vertical lacerations were tearing that Dr. Steer testified aligned with the spaces between Sayla's teeth. You can be the judge of that alignment. You can see the pictures, whether it was on the inside of the lips as Dr. Steer testified to, or whether simple drying and cracking of the lips along that distribution of her teeth is consistent with any realistic alternative explanation for their appearance. Dr. Steer noted petechial bleeding in the heart and lungs, evidence which he indicated was of breathing against an obstruction. He also noted thoracic hemorrhage or bleeding extending into the neck. As well as that frothy bubbling in Sayla's lungs, evidence again of breathing against obstruction. Well, there's no dispute that on May 31st of 2018, Sayla was in the sole care of Alexis and Lori Berry. And to find the defendants guilty of first-degree reckless homicide, he's been instructed that he must be satisfied beyond a reasonable doubt of 3 elements. First, that the defendant caused Sayla's death. Certainly, manual suffocation meets that definition. Second, that the defendant caused that death by criminally reckless conduct, conduct that the defendant was aware created an unreasonable and substantial risk of death and great bodily harm. Again, holding one's hand over the mouth to the point of lacerations to the lips certainly meets that definition. Finally, the element of utter disregard for human life. I can think of no more personal disregard for human life than smothering it out of an individual with the manual application of force to their nose and mouth. In addition, the suffocation occurred with the backdrop of evidence of significant physical injuries across the range of Salah's body, as you've seen, most of which the Berries claim were either minor first aid injuries or injuries they simply weren't aware of. In addition, Lori and Alexis Berry allowed Salah to lie dead on the floor for hours before calling 911. This is utter disregard. To be guilty as a party to the crime, you were instructed that Lori and Alexis must have either directly committed it or aided and abetted in doing so. Again, Dr. Steer has testified to the required medical legal standard that it was more likely than not that more than one perpetrator was involved. What further evidence do we have to support this? Recall the two things that Lori and Jesse Berry said would result in physical discipline in their household: lying and utter defiance. Amidst the stress of moving into a new house, Jesse Berry taking a new job, extended family living with them, dealing with a special needs child of their own, and the unexpected ramping up of behavior by Salah Caden, including recent physical aggression against Lori Berry, fighting, pinching, scratching, and pulling at her hair. I submit to you that Salah's caregivers likely did employ physical discipline with her. As expected by Lisa Caden, this would have triggered a fight-or-flight response from Salah. The discipline escalated, as evidenced by the numerous acute, again as Dr. Steer testified to, minutes or hours, lesions all over Salah's body. Lori and Alexis sought to get her under control, eventually covering her airway to the point she could not breathe, and ultimately suffocating her to death, likely sometime around or shortly before noon on May 31st. Now, this time of death matches up well with Lori's comments of Dr. Sharpswain of Salah's stiff legs around 2 o'clock, and Jesse's comments to Dr. Sharpswain of her arms and legs being stiff when he came home. It also explains her extremely cold touch by the EMT and her 91-degree body temperature, and the inability of medical personnel to open her clenched jaw. Salah had not been exhibiting normal muscle tone earlier in the day. She had been displaying rigor mortis. She was already dead. I'm sure the Berries didn't want to believe they'd killed their friend's daughter. Perhaps they even convinced themselves of movement, pulses, and breathing where there was none. But the medical evidence is clear that Salah was dead well before 911 was ever called. Lori and Alexis Berry were the sole caregivers to Salah on May 31st. And not only were they ready and willing, but they were assisting each other throughout the day. Although they claim they were assisting in caring for Salah, the physical evidence instead proves otherwise, beyond reasonable doubt that they were assisting each other in taking her life. Now, the defense experts in this case have done exactly what defense experts are hired to do, to shift your focus to things that aren't there, in hopes that you lose focus on the facts as they actually exist. The judge cautioned you that a reasonable doubt is not one based on guesswork or speculation, and that you're not to search for doubt. But that's exactly what the defendants are asking you to do, despite the physical facts supporting their guilt. What has the defense pointed to? Let's go through some of those theories. Self-injury. Again, no evidence in roughly 4 years of counseling history of any self-injury. The Berries never informed the Cadens of this alleged self-injury behavior until the day of Salah's death. And Dr. Christensen himself testified that none of the blunt force injuries on Salah's body would have been sufficient to cause her death. Hypothermia. 67 to 68 degree home, indoors, Salah was clothed. She was blanketed for much of the, at most, 3 hours that she was lying on the floor. She was sitting on someone's lap for at least 2 hours before EMS arrived, again with a blanket. If this is the type of scenario that leads to hypothermia, Upland Hills is going to be extremely busy in the next few months. Common sense tells you she was not hypothermic. She was already dead. Again, this squares perfectly with Dr. Steer's testimony regarding rigor setting in, and the statements that the Berries themselves made to Dr. Sharpswain at the emergency room. Even Dr. Christensen acknowledged that the history of that afternoon provided by the Berries themselves was not at all consistent with someone suffering from hypothermia. Also heard the defendants talk frequently about a blood disorder and Salah being anemic. There were no indicators of anemia. She was never described as short of breath, fatigued, dizzy, weak. She wasn't on any medications for her disorder, no history of blood transfusions. By all accounts, Selah was a healthy, active 13-year-old girl. Cardiac arrhythmia. Again, no indicators of any cardiac issues, no medications for cardiac problems, no discussion of any cardiology visits. Same for seizures. Jesse Berry himself testified that with the information that Lori gave me as far as physical things that Selah had done in the interim between when she fell and each time she talked to me, I was confident that there was no sign of significant head injury. There was no sign of any other major problem as far as respiratory or cardiovascular. The defense pointed to CPR as a possible cause of some of Selah's injuries. But again, no evidence of broken ribs, no evidence of punctured lungs, nothing in the medical records to suggest injury by medical personnel. Ultimately, what you've heard from the defense experts is a lot of couldas, maybes, possibilities, because they have to ignore common sense against the backdrop of a girl with evidence of significant blunt force trauma all over her body, and evidence both internally and externally of death by manual suffocation. With that background, only Dr. Steer's opinion as to the cause and manner of Selah's death is credible. You've been instructed in this case that you're to search for the truth. And that search is not a difficult one, given the facts of this case. Even the defense's own forensic pathologist agreed with much of what Dr. Steer had to say in terms of findings. He agreed on the presence of vertical striations on Selah's lips, the presence of hemorrhage in Selah's chest and into her neck area, the presence of the epicardial petechia and hemorrhage, the presence of numerous blunt force injuries to Selah's scalp, face, torso, and extremities, including patterned contusions and abrasions, the presence of a painful wrist fracture, a wrist fracture that somehow went unnoticed during the course of the entire afternoon. The extensive contusions and abrasions on Selah's buttocks and the patterned injuries on her chest and back. And most importantly, Dr. Christensen agreed on a differential diagnosis that included asphyxiation, whether smothering or suffocation, as a possible cause of Selah's death, which he also acknowledged could have occurred prior to her arrival at the ER. Nurse Riston shared her views on suffocation and strangulation as well, particularly with the evidence that wasn't seen in Selah. But recall that she's not a doctor, she's not a forensic pathologist. She had dealt with exactly 0 cases of hemoglobin H disease in the context of a strangulation or suffocation, and had handled only a couple of cases of child strangulation or suffocation as a forensic nurse. Yet even she acknowledged that the force required to suffocate a child would be less than that required to suffocate a grown adult. And that correspondingly, that the presence of defensive injuries on a perpetrator would be less likely with a child victim. Ultimately, you're being tasked with weighing the opinions of all the witnesses in the case. Common sense, reason, logic, life experience can and should inform the weight that you give to their credibility. There's no room for doubt in this case, certainly not reasonable doubt on who and what caused Selah's death. Common sense tells you that the version of what happened the afternoon of May 31st as provided by Lori, Alexis, and Jesse Berry isn't what happened. Simply saying it over and over again doesn't make it any more plausible. Facts support beyond reasonable doubt that Lori and Alexis Berry are guilty of first-degree reckless homicide with the manual suffocation that caused the death of Selah Tatum. And I would ask that you find them guilty accordingly. Thank you.
Your Honor, I will be frank. I think I'm going to talk longer than Mr. Allen, and I know I would be more comfortable if we could take a 5-minute restroom break before I start.
All right, let's take, we'll come back at 10 after. All right, all rise for the jury. until 10 after 10.
Thank you.
You're welcome.
You wanna-
How is that mic working out for you? It's all right? Okay.
Appreciate it.
You bet.
Are you okay if I pop up there quick just to get
Yeah.
some fresh batteries?
Yeah, yep.
Wisconsin versus Alexis Berry, 19 CF 100. Appearances have been made. Ms. Nicholson, are you ready?
Yes, Your Honor, thank you. Good morning. Defense experts did what defense experts do. Let's start there. Eric Christensen, not a defense expert. Tristan Riston, not a defense expert. Eric Christensen is the chief, the head of medical examiner's office in Utah. He supervises 9 other pathologists. He testifies regularly for the prosecution and is employed full-time by the state of Utah. He does consulting on the side. He's not a defense expert. He's an expert. Tristan Riston, same story. Employed with a contract by the prosecution, has a consulting business on the side, testifies regularly for the state, testifies for the defense when appropriate. Not a defense expert, an expert. 30 years of qualifications in Eric Christensen, and that is waved away by one sentence at a closing argument of a lawyer. Let's talk about what Mr. Allen didn't talk about on the subjects of experts. Michael Steer. And we're going to come back to him. But we need to start by talking about all of the different ways that this case requires you to acquit the Berrys. There are many ways that we can evaluate this evidence. All of them lead to reasonable doubt. So let's start with first things first. What are the facts? I dispute much of what Attorney Allen said with regard to the facts. He said there's no evidence of self-injury in the record. False. There's a packet of counseling records that were moved in. In that counseling record, there is an email that Lisa Caden sent to the therapist, to Dana Horn, discussing that Selah would do anything, including pick at her own skin. The Cadens both testified this was a self-injurious behavior, that it had gone on for years. There are discussions about other unsafe behaviors that can cause accidents or harm. Wearing no shoes on a roof in the winter as you climb out a window is a self-injurious act in the sense that it puts you at risk. And no one has come in and said all of a sudden she started cutting herself. What we said is we saw a change in behavior that was consistent with what was expected, which is she engages in behavior that seeks attention. The fake feigning, and again, this is from Lisa Caden. Lisa Caden described that there had been another kid at school that had talked about fainting, and that was something that they put together, and it wasn't unexpected because that sort of attention-seeking behavior is consistent through those years of counseling records. No, I don't think she started putting cigarettes out on herself. Nobody said that. That wasn't what was argued. But she does have a history of intentional acts that cause other people to pay attention, and part of that can be things that result in injuries. That's what the testimony was from the Cadens and the Berrys. That's what the doctors talked about in terms of evaluating the possibility of self-injury, is these feigned falls and repeatedly going down over and over again, hitting the ground, hitting the gravel, hitting the stairs. That's what we're talking about. It's misleading to suggest otherwise. 2, the prosecution's absolutely right that I'm going to tell you that we don't know what happened in that house, and that the prosecution can't get up here and tell you who did what. I would suggest to you that that's actually where this inquiry ends, because what you are tasked with doing is figuring out how this death was caused. First, you have to accept that it was homicidal suffocation, and I'm going to come back to that, and why you shouldn't. But then you have to decide that someone covered the mouth of this child for minutes, several minutes, while the other did what? I guess, sat and watched? Lori Berry sat and watched while her daughter suffocated the life out of Salem Kid? Sat there and watched? Alexis Berry sat there and watched while Lori Berry suffocated the life out of Salem Kid? State's charged that as a reckless act, but suffocation is pretty intentional. They can't tell you who did what because there's no evidence to support that either of them did this. The state says the physical evidence all lines up. What physical evidence? What physical evidence? Nobody swabbed her fingernails, nobody swabbed her neck. The blackjack that was found in Emily Berry's purse in a locked area of the house that was separate from the rest of the Berry family, that didn't match. The ropes didn't match. What physical evidence are we talking about? There isn't any. There isn't any. What you're asked to evaluate is first, can you say what happened beyond a reasonable doubt? He can't say it at all. He doesn't know. Nobody in this room knows. And yet, because my experts tell the truth about that, because they say sometimes we don't know everything, that makes them less credible than the guy that lies under oath to support his conclusion. I don't get the logic there. I want to talk about this. When Dr. Steer was on the witness stand, I read him this affidavit, and it's hard to follow when you can't see it, okay? And I know you all paid attention. You've taken great notes. First of all, affidavit means I declare under penalty of perjury. That means it's under oath. He talked a lot about oaths. That was pretty offensive to me. We'll get to that. He signed it. He read it. He's a doctor. He can read. He fought me on the idea that this acknowledged that he lied. He was lying to you when he fought me about that. Let's look at what he said. I testified I did not observe a skull fracture. When the prosecutor asked me to explain what I described as a skull bone irregularity, I'm skipping, I responded, I'm not saying it is, I'm not saying it isn't. At that time, I felt pressured by prosecutors in the case against Ms. Hancock to leave the door open to the possibility of a skull fracture. However, if I were called to testify today, I would definitively say that there was no skull fracture. That's not involving science. He didn't learn something new. He was pressured by prosecutors to lead a jury to believe that a skull fracture existed when none did. You might think that's a minor point. But you see the name up there, Miss Hancock? Miss Hancock is a person who had a baby. A little boy, initials LW. And that little boy died. And that's unimaginable to live through, a parent losing a child. What the Cadens lived through is unimaginable. But compounding that for Miss Hancock was she was accused of killing her child. And the person that she looked to, the doctor, first do no harm. That's their oath. The doctor, who was supposed to be a neutral, scientific, medical professional, intentionally misled the 12 people in the box that probably didn't have medical degrees, just like I do, and let them believe that that woman cracked her baby's skull when he knew she didn't. No one should ever believe him again in this courtroom. No one should ever believe him again. Where do you think Miss Hancock is right now? The unimaginable tragedy of losing a child, to then be falsely accused and have the people who are supposed to be the neutral witnesses mislead that jury? I have a word for that. It's not a medical term, but it is torture. That's what Miss Hancock experienced because of Dr. Steer's lies. And they were lies. To me, we don't even need to talk about anything else he said. sometimes what you do is so defining that it takes away the rest of the evaluation of your character. You've been read instructions about the credibility of witnesses and how to evaluate that. Sometimes someone does something that you just never believe them again. And I am telling you that lying to a jury about a homicide is one of those things. It's one of those things. He goes on though. It's not his fault he lied under oath. Defense counsel didn't ask the right questions. I can't tell you how much sleep lawyers lose when they know that their client's fate and their client's liberty is in their hands. And I know I'm not a doctor. I have an art history degree, okay? I know. We do the best we can. And we prepare and we work with our experts, who I guess you can dismiss with one sentence. Defense experts do what they do. I guess you can say that. But instead, they put in hours and hours of work to educate the lawyers. And at the end of the day, this guy that the state asks you to believe beyond a reasonable doubt when he doesn't even know what the standard he testified to means. This guy says, if the defense attorney had only asked the right question. That's an enormous amount of pressure, ladies and gentlemen. It's an enormous amount of pressure. And I hope I asked the right questions to show you everything that is wrong with Dr. Michael Steer. The state was critical of the experts that testified on behalf of the Berry family because they said it could happen. That's possible. Perhaps. Yeah. You know why? Because the finding was cause of death is undetermined. What does that mean? It means that Eric Christensen did not know. So he's going to evaluate all of the injuries, all of the evidence, look at possibilities for each. And did you notice, no wonder Mr. Allen wants to dismiss defense experts so quickly. Because Eric Christensen told you the standard in the state of Utah is that two pathologists have to agree before they'll pronounce something a homicide. Two have to agree. Seems like a pretty good idea to me. In contrast, Michael Steer testified that he's done 4,000 autopsies and he always does them on his own. He said, well, I've collaborated on others, but my findings are independent. Medical history? Why would I need a medical history? Why would I need to know the facts and circumstances that lead up to a person being found dead? That's contrary to his own procedures. I asked him questions about the presentation he gave teaching other people how to do his job. Lucky us. First thing, general outline. Gather appropriate historical information. Didn't do that. Goes through exploring, sampling for toxicology, collecting case-appropriate evidence and photography. Two people from the crime lab there. Doesn't swab the fingernails, doesn't swab the throat. I understand the argument that some DNA would be on Selah Caden because she lived in the Berry household. I would suggest to you that it is very unlikely that Alexis or Lori Berry's skin would be under her fingernails unless she had been involved in the struggle. The state has tossed out some truly bizarre explanations for that, which I guess Lori Berry, in some strange plot days before to cover up a homicide she was contemplating, had Selah Caden cut her fingernails. Sure, I don't know, that seems wild to me, absolutely wild. And it seems wild because, as we'll talk about, there's no indication that the Berrys are the type of people who would have done what they're accused of, and I'll get there, but I want to talk about Steele. He also says he should have had the clothing items and the weapons. I asked him, did you get the blackjack? Nah. No. That's his procedure. I didn't make this up. Eric Christensen didn't make this up. That's what he teaches people to do. And he didn't do it here. Why? Because he made up his mind. He had decided, and as you heard him say, he's an advocate for his own findings. He said that. In contrast, Eric Christensen said, I'm an advocate for the decedent. Here's the thing. When the cause of death is undetermined, it doesn't feel like you're advocating for the decedent. Because you want to know the answer. You want to solve the puzzle. But truth is the best form of advocacy. And sometimes the truth is you don't know. Now, the state suggested that our experts said some things that they didn't. I asked Eric Christensen, are you saying hypothermia caused the death? And he said no. I'm saying that the cold temperature, the floor, her anemia, which again, the state says, oh, there's no evidence of that. Lisa Caden agreed she's anemic. Everyone agreed she was anemic. So why we're here in closing argument denying that part of her medical history is totally beyond me. Because her parents agree that that's true. Anemia, as even Dr. Steer told you, can affect temperature, can affect the appearance of bruises. This isn't an excuse, it's a reason. What Christensen said was that her being thin, her being anemic, and her laying on a cold floor could have contributed to the presentation of her body as cold and as a little stiff. And he told you that it wasn't rigor. And he told you that because you wouldn't have been able to intubate her, and you wouldn't have been able to get an IV in, and you wouldn't have been able to position her the way that Alexis and Lori described. Her body would have been stiff. She couldn't have gone limp. She couldn't have been placed in Alexis Berry's arms. And what has the state done to suggest to you that these people haven't told you the truth? They've relied on Dr. Steer's claims about time of death. Now, let's talk about that. He actually, and I wrote it down, put that time of death could have happened as far as 36 hours, 10:35 p.m. on the 30th. Now, Dr. Christensen rightly tells you it can be predictive, but we can't say for sure. I guess in the state's mind, about time of death, not about the 36 hours. He laughed at that on the witness stand, I remember that. But what the state wants you to believe about that is because Dr. Steer testified wrongly to an opinion that he's sure of, that somehow gets more credit than a doctor that testified truthfully but can't give you all the answers. That's crap. I don't know how else to say it. It's crap. 36 hours or 24 hours. Let's talk about what was going on in the Berry household. If Selah Caden had been dead 36 hours ahead of time, somebody would have had to put her in her bunk bed and leave her there the whole night. Somebody would have had to, the next morning, gotten her body out of the bunk bed, carried her up the stairs from that basement room, and then put her in the living room. Lori and Alexis Berry would have then had to come to some agreement that the way they should handle this dead child is to fake a series of phone calls to the Cadens asking for guidance and direction. To fake a series of phone calls made to Jessie and Charity Berry asking for direction. To fake asking her husband to come home early to check on this kid. The state suggests that there was no reason to check on her. That's not what the testimony was. The testimony was she had hit her head at least twice. That's certainly a reason to check on someone's responses. Look, I don't think it was hard enough, and that's what Lori told me. I didn't think it was hard enough to cause a serious problem, but head injuries are dangerous, and so I wanted to keep checking. Now, what's important here is this isn't some wild new story about Selah's behavior. This is behavior that the Cadens said, well, it wasn't exactly what she did before, it was pretty consistent with what she does. And you know, I have to pause for a minute and just tell you that I truly regret that the picture you've gotten of Selah Caden are either those autopsy photos or a description of her negative behaviors. because I, like everyone else, heard her voice in the letter that was read into evidence and her talking about not wanting a brother. And I have heard how everyone described her having a great sense of humor. And being a kid that was troubled, but that wanted to be loved. And that's how I would prefer that Selah Caden were remembered. Not like she looks in those autopsy photos with lividity settling in to make those bruises look more egregious than they are, and you heard testimony from all of the doctors about that. Not in some imaginary scenario concocted by Dr. Steer, but who she was. And trials don't facilitate that. And that's really sad. And it really is. So again, just as we talked about in jury selection, I don't point to these behaviors because I want you to think ill of Selah Caden. I point to these behaviors because they provide explanations. You've been asked to consider reasonable doubt. Reasonable doubt means a doubt based on reason and common sense. It means a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon in the most important affairs of life. There are few things that are more important than a homicide trial. You have to be sure. Here's what sure isn't. Sure isn't Dr. Steer aggressively asking Attorney Van Wagner on the witness stand, well, you tell me, how do you define a reasonable degree? 51%? 75%? Question, so you don't even know what level of certainty it requires. Answer, that's correct, I don't know. Pause again and think about the Miss Hancocks of this world. This is the neutral medical expert. This is the person that all of you, the people like you, sit and listen to and depend on for the right information. You know why? Because no matter how qualified the experts I call, in one sentence the state's going to get up and say, defense experts, they do what they do. The real expert is the state expert. That's what he told you. 30 years Eric Christensen's been doing this. 15, I think, Tristan Riskin has, but they're going to rely on this guy. How many thousands of autopsies has he done? How many hundreds of determinations of homicide has he made? How many times has he sat in that chair talking to people like you, testifying that he's certain? He's certain. When he doesn't even know what the standard means. That should be enough to discredit his testimony. But there's more. There's so much more. He tells you the major finding, because all of these injuries, okay, and they say, oh, you've come up with lots of explanations. Dr. Steer didn't try and come up with any other explanations for these injuries. Though notice, on cross-examination, he did acknowledge the following things. I asked him about holding a bottle and if it were metal and pattern injuries. He agreed with me that pattern injuries are not always abusive. I asked him about distinguishing between a blunt force injury, those small round bruises. I asked him, isn't it the same thing as if I run into this by accident or if someone pushes me into it? Yes. Pattern injuries. Explanation for. Small bruises. Explanation for. A number of times, he told you he didn't know what caused the injuries, including sometimes where he really should have if he's such an expert. Like that hemorrhage to the wrist. Dr. Christensen immediately told you, well, yeah, it's from the fracture. The fracture that is consistent with a fall. He didn't know what that was from. He was asked about the injuries to the chest and the thoracic cavity. He didn't know what those were from either. He said, I don't know. I don't know what those injuries are from. So yes, she has a presentation of injuries, non-lethal injuries. Those bruises did not kill her. Everyone agrees about that. But there's nothing, even in Dr. Steer's testimony, that tells you beyond a reasonable doubt that those were abusive injuries. He can't even tell you to what percentage he thinks he's right. I guess at the end I got him to agree it was 51%. 51% really isn't close to beyond a reasonable doubt. But his major finding, why he got to homicidal suffocation, was the presence of the injuries on the lips. Okay. Number one, the state says there's no other explanation for those. False. In addition to the fissures and the dried lips as they talked about, they made efforts to intubate her. And you heard Dr. Christensen and Tristan Riston tell you that efforts to intubate can cause that. Number two, the injuries that he says he saw in the lips were not there and were not supported by the microscopic slides. He says there's almost no hemorrhage to these because I believe they occurred during the dyeing process. You heard Eric Christensen say, that doesn't make any sense. That if someone is being suffocated, their body is still responding to the trauma. Inflammation stops when you're dead. So if she is participating in the lethal event, in the suffocation, there would be inflammation. Christensen told you that. That also, to borrow a phrase from the state, makes sense. Deceased people don't respond to injuries, they don't heal. Living people do. And why did I bring an expert in here to talk to you about what happens to the living in cases of strangulation and suffocation? A few reasons. First of all, as you may have noticed, Dr. Steer repeatedly switched between suffocation and strangulation. They are two different mechanisms. But at one point, when Mr. Allen was questioning him, Mr. Allen actually said, well, wait, strangulation, don't you mean suffocation? And he said, no, strangulation. That was when he was talking about this new opinion he had about the throat. There are some common hallmark injuries between suffocation and strangulation, and Ms. Riston told you about those. She also told you that there are a number of injuries that you would expect to see in a suffocation or a strangulation that required lethal force that were simply not present there. What were those? There were injuries to the eyelids and eyes that you didn't see. Injuries behind the ear that you'd expect that you didn't see. There's the inflammation and the actual interior cuts that you would see with a suffocation or a smothering mechanism in the lips. You would see you'd see hemorrhage. She told you that. You would see petechiae on the face, the eyes. You would see things in the chest. You would see it everywhere. Or at least you'd expect to. Now, she told you the truth, which is sometimes suffocation can present with none of the associated injuries. But it's not the most likely thing that happens. It's not. She told you the most likely thing that happens is you would see all of those hallmark injuries. Both Ms. Riston and Dr. Christensen disagreed with the findings that Steer made that relate to Steer's conclusion about cause of death. Again, I could stop right there. That's reasonable doubt. You've got two experts, they have conflicting opinions. I would suggest to you that Eric Christensen has not been impeached on his credibility and that Steer absolutely has, so I would resolve it in favor of Dr. Christensen. But you don't need to do that on a one-to-one basis. You can account for Tristan Riston's conclusions. But even 2-on-1 isn't what makes the difference. What makes the difference is she told you the truth. That yes, sometimes how things look aren't how they are. Sometimes what we see isn't what it is. So sometimes someone can die of suffocation without there being an injury, and sometimes someone's body can feel cold without being dead. Okay? The way things look aren't always the way things are. The state seems to think that her honesty makes her less credible. I submit to you it makes her more credible. She didn't want to push her conclusions to conform to the defense's theory. Neither did Eric Christensen. Both of them told you. And it's not a surprise to me that they would both say, well, of course we flag this as concerning for child abuse. There's a kid with bruises. And they should. There is a long way to go from flagging something as concerning for abuse and making a phone call to convicting people after finding proof beyond a reasonable doubt. And you've heard nothing other than Attorney Allen's argument that because Jesse Berry had a new job and they had moved, there must have been a lot of stress. I didn't really hear that from those witnesses. That Lori Berry must have been frustrated because Selah had a little bit of a physical episode a few days prior. I didn't hear that from Lori Berry. What I heard was that these were all behaviors that were expected. These were all behaviors that were anticipated. They didn't make her outraged. They didn't make her angry. They didn't make her homicidal. She's got a little one at home that has the same problem, Samuel. She deals with this every day. What evidence were you shown to suggest that either Lori or Alexis Berry would, after a lifetime of being people that the Cadence trusted, that the community has trusted, that have lived their life in a way that's dedicated to faith and hope and kindness, that some switch hit and they became not just homicidal monsters, but the kind of people who would lie over and over again to their good friends and lead their good friends to believe that their daughter was alive and needed help when she'd been dead for hours. Not to mention, by the way, that both Lori and Jesse Berry have medical training, so if they were going to concoct a story, they probably could have come up with one better than she wasn't dead. The reason they told you she wasn't dead is because she wasn't. Eric Christensen told you that that is completely possible and consistent with the evidence. Can he tell you for sure that they are telling the truth? No. He's not supposed to. Number one, that's your job. But number two, that's not a medical fact. Their truth, not a medical fact. We had some confusion about medical facts with Dr. Steele. Torture is the one that I've mentioned. Torture is not something that is subject to an opinion to a reasonable degree of medical certainty. So if you use the word torture, you're using it in a non-medical way. Well, I'm using it in a medical way. I don't even know what that means. It's a two-perpetrator theory. I don't care how much gymnastics have been done mentally to try and convince you that that is somehow a medical fact. The only reason that he said that is because he knew there were two people in the house. And if he doesn't say that, if he doesn't give you a reason to convict these two people, then it'd be hard to hold them both accountable, right? So he has to give you a reason. That's not medical. I asked him, isn't it true that the only thing that limits the amount of injuries I can inflict on another person is my own fatigue? Yes. Selah weighed 71 pounds, I think. Are you really telling me that two people would be needed to abuse a 70-pound girl? He goes on to be even more bizarre with his claims because he explains that after this terrible beating that he's envisioned, and how many times did he play in your sympathy? You know, between the, oh Lord, and oh God, because he was uncomfortable from his medical condition. Do you think that was a truth-seeking function, or do you think he wanted you to feel bad for him? And his statements that, well, I looked at these impression marks on the wrist, and I've come to the conclusion that after she had been beaten repeatedly, someone must have tied her unconscious body up. What evidence exists to suggest that? These bruises were not symmetrical, the way you would expect with apparent restraint marks. There was no evidence of struggle or force there. That makes no logical sense. To tie up an unconscious 13-year-old? And by the way, if they did that, where is the ligature? Because another thing that you have to believe to convict the Berries is that somehow they got rid of the evidence of this brutal beating and suffocation while they're making phone calls to 911 and EMS is arriving. They went straight to the hospital. That's a fact beyond change for the state. They didn't have time to clean this scene up. I suppose the other members of the Berry household could have done it because we're looping this entire extended family into this conspiracy, if you listen to Dr. Steer. Because you've got Eric and Emily who live right across the border there, the locked door, and their kids who, Emily testified, regularly went in between or were around outside. So I guess Alexis and Lori Berry must have been suffocating this girl. Well, this whole family of people is, you know, one door away, and they know they come in at any time, but the rest of the Berry family just went along with that. Jesse Berry just instinctively went along with the lies that the state needs you to believe the Berries told. Just said, oh yeah, sure, I felt a pulse, called 911, told them that. Why? Exactly. The state doesn't have to prove motive, but it's a question you get to ask. You get to ask, why would these people have done this? What could this little girl have possibly done? What behavior could she have possibly engaged in that would cause two people who are experienced with reactive attachment disorder kids, because Alexis and Samuel are brother and sister for all intents and purposes, perhaps not biologically, but morally, legally. She's lived with Samuel since the time they got him when he was a little guy. These two people who are experienced with this behavior would suddenly lose their minds to the point that they're homicidal. What evidence exists in their character that you've heard about to believe that? It's not true just because the state says it. It's not true just because someone's charged with a crime. That standard is a different standard. That's probable cause. Dr. Steer told you that the marks on the neck were most consistent with fingernail marks. Both Dr. Christensen and Kristen told you that's not true. Fingernail marks have a half moon curved impression. That's not what those marks were. I asked Dr. Steer, again, the one person here who calls this a homicide, who you're supposed to take his word as gospel. I asked him questions about the history. You didn't know she was anemic, didn't know she has reactive attachment disorders. No. How do you explain injuries if you don't know that there are alternative causes? You can't. You have to do the work. He didn't do the work, it was on his own slides. Again, when I go through this, the wrist, the hemorrhage, I don't know what caused that injury. I don't know what caused the bruise to the top of the head. There was a hemorrhage on the left arm, I think you said. I still don't know how that came about. Unfortunately, you don't get the transcript of Dr. Steer's testimony. I had that prepared, but that's what I'm reading from. I don't know. And the state gets up here in closing argument and tells you that our doctors are unreliable because they tell you that things could have happened one way. Their doctor doesn't know about every injury. Virtually every injury. If you were to fall down the stairs, you could hit both your legs and your buttocks. True? I suppose. The thoracic hemorrhage that goes up into the neck, you don't have an explanation for. Answer. I believe I said that, yes. So you agree with me that you can't say for certain, even in this case, that every injury was an abusive injury. Answer. It depends how the jury defines abuse. Defense experts do what defense experts do. What did that guy do? Let's talk about all of the things that we have to believe to get to a conviction. First of all, you have to believe this doctor, which I hope I asked you the right questions. I hope I asked him the right questions. I do. I hope I've demonstrated it. You have to believe that his testimony, full of those I don't knows, full of those exclamations, full of those efforts to influence your emotions by telling you think about what Salem must have gone through. How many times did Eric Christensen say, I wouldn't have testified to that because that's not a medical opinion? It's not a medical opinion. Dr. Steer knew some of you were deer hunters. You probably are, but you know what that is? That's a guess. It's a guess that has some education behind it because we're in Wisconsin and people hunt in Wisconsin. So that's a fine thing to guess about. Because whether or not you're deer hunters aren't the most important affairs of daily life. It's okay for him to guess about that and be wrong. It is not okay to guess about this. So you have to believe him, even though he's misled juries before. And I've talked about that. It's a very hard thing for someone to watch, because just like he took an oath to do no harm, I took an oath to protect the Constitution when I was sworn into the bar. And the process is all we have. So when someone who's supposed to be reliable and neutral gets up there and misleads juries, it is deeply offensive to what the system is about. It is deeply and dangerously offensive to what the system is supposed to be about. We cannot reward that behavior by dismissing the qualifications of two extremely well-educated and well-spoken experts who work for the state in their own right. Why did they come from out of state, by the way? You heard Dr. Steer testify about the culture. He didn't put in the affidavit that medical personnel had pressured him, but he testified on the stand that he had felt medical pressure too. I don't trust Wisconsin's culture of how they worship these experts and hold them up as infallible. I'm a good lawyer and I miss questions. It's why I stay up at night worrying if I've asked the right ones in this case. Mr. Van Wagner's a good lawyer, he misses questions. Mr. Allen's a good lawyer, he misses questions. But you're all supposed to believe that that guy never got a single thing wrong. And even though he can only tell you that to 51%, that's beyond a reasonable doubt. Mr. Allen asks you to use your common sense. In what universe does Dr. Steer's testimony alone satisfy this burden? There's no universe of reasonableness that it does. There's no universe where if we apply common sense, that gets him over the hump. I understand why this case was charged. There's a huge difference between why something is charged and whether or not you convict. So you have to believe him. You have to believe that for no apparent reason, two qualified people who work for the state, transcripts, we produce them, I'm reading from one. You think that the transcript of Eric Christensen's testimony won't end up on some lister for prosecutors if somebody has a case where he's the expert again? Where do you think I got that affidavit? Lawyers talk, we know. Those two people would have gotten up here and lied to you, I guess because I paid them money. Much was made that at whatever $500 an hour that an experienced pathologist has earned the ability to charge that Dr. Christensen cost $12,000. What they didn't tell you is Dr. Steer was paid quite a handsome salary the entire time that he worked for UW. And when you start a case, you have to finish it. So if you did the autopsy, you have to come testify. So was he paid for his testimony? Yeah, actually. He was paid in the form of a salary. Just like Dr. Christensen and Tristan Riston were paid in the form of the salary that they are entitled to from performing the work of their job. So you have to believe Matt Allen's one-sentence defense experts do what defense experts do. You have to believe the word of a liar. And you have to believe that every member of the Berry family got up for hours and lied to you. You saw Alexis Berry cry on the witness stand. You think she faked it? Now, the credibility of witnesses instruction tells you to consider the motive for falsifying testimony. I expect that Mr. Allen in rebuttal will say, well, they're on trial for murder. Of course they'd have a motive to lie. But they weren't on trial for murder the first time they talked to Lana Bowers. They weren't on trial for murder the second time they talked to Lana Bowers. Or the third time, or the fourth time, or when they testified at the coroner's inquest. They weren't on trial then. The reason the state has the burden of proof is because you cannot prove you didn't do something. The best you can do is get up and tell people what happened. And they did that at every opportunity they had. From the moment they could speak to the detective, they did, to both of them choosing to take the witness stand. They're not doctors either. They can't bring a slide in that, if you examine under a microscope, tells you whether or not there's reasonable doubt in this case. But they can tell you the truth. And that's what they sat here and did for the better part of the day when you heard both Lori and Alexis testify. You see me looking at this and all of my tabs, and I know that you took really careful notes. I saw all of you. And I keep coming back to it again and again. Because once I sit down, I don't get to talk again. Mr. Van Wagner will talk. Mr. Allen will talk to you. Anything that Mr. Allen argues in rebuttal, I'm not going to have the chance to get up and say, wait a minute, that's not actually what happened. Remember when Steer said this. Remember when Christensen said that. I don't get to refute it. Once I sit down and talk, I give her to you. I give her to you, this woman that for the last 2 years I've gotten to know. This woman that Lisa Caden, Dave Caden knew the heart of and trusted. This woman who's a caretaker and a mother. And honest. When I stop talking, I give her to you. And I have to trust that I asked the right questions to show you that Michael Steer belongs nowhere near that witness stand. I have to trust that I've done a good enough job to show you what common sense should all along. You don't know what happened. No one does. It's awful, and it breaks our hearts. That's why it's hard for me to sit down. I'm asking you to do your job today, to apply the burden of proof, to believe the Berries, to discount the word of a liar in favor of the honest uncertainty that exists from Eric Christensen and Tristan Riston. I'm asking you to find Alexis and Lori Berry not guilty. And I don't get to ask you again. So please, look at all of it. Don't wave it away. Thank you.
I rise only to ask the court if it wishes to inquire of jurors if they want a short break for the next two closings.
Would the jury like a break?
Okay.
How many want to continue? Raise your hand. All right. Go ahead, Mr. Becker.
May I use this counter? Am I on mic? Ladies and gentlemen, I've been at this for over 40 years, and every time I do it, it's like the first time again. Because every client I represent has the same thing to say. But I've done some studying over the years and some reading. I'm going to tell you something that most lawyers refuse to believe, and all TV producers on Law and Order and its progeny refuse to believe. And that is that closing arguments generally do not win cases. Now, we've all watched Law and Order, or some of us have, and they always give a 2-minute closing argument that's it's Hollywood, it's drama, and they make the most compelling argument for each side, and that moves the jury in ways like Perry Mason. The studies that have been done of the juries that deliberate actually tell us that most jurors, if they change their mind during closing arguments, is because they made a tentative decision of just hearing opening statements, hearing witnesses. Your brain processes it. And that lawyers are more likely to lose a juror or 2 or 4 in a closing argument than a gain. Well, there's a lot of ways to do that. One of them is to talk for a long time. And I made a note that I started at 11:06, and I'm going to put it right on my file. Because if I'm still speaking past 11:30, I'll ask the bailiff to escort me out. You've heard too much already. So, the first thing I'm going to take on is this. I made some notes. Yeah, you saw me bring a lot of papers up here, but it's just guides. It's mental guides. I know my case and I know what I want to tell you, but what I want to start with is a few. I'm so thankful for 3 and having invented these little puzzles. They're really helpful. I heard the prosecutor say in his initial argument, this was at 9:52 a.m., the defense wants you to search for doubt. No, we do not. We don't want you to search for doubt. We want you to follow the jury instruction that says you are to search for the truth. But remember that it doesn't say you are going to be able to find it beyond a reasonable doubt. Way back in the beginning of the case, we talked in jury selection, and I spoke in open about how there's 2 judges in a courtroom. There's the judge of the law, and she sits behind me to my left. She decides which of these instructions you hear. You folks are the judge of the facts. I'm not making this up. In the second page of your jury instruction, I'm going to quote, you, the jury, are the sole judges of the facts. And before you can return a verdict, you have to figure out what those facts are. And if you can't, then you can't decide if a crime occurred. And I will quote the prosecutor who said, you're not to engage in guesswork. And yet I heard him say, perhaps they chose not to believe she was dead. Perhaps. He also said in opening there were 2 sides to every story. Well, yeah. Why? Because the stories here, if you want to call them that, are stories that mainly come through opinions, not the facts, except to the witnesses who are present. So I went through these jury instructions this morning, and I circled and highlighted 3 words every time they appear. Let me start with this. The word act, or acts, A-C-T-S, is in the jury instruction packet at least 5 times. What is an act? This is an act. I just banged my pen on the counter. Now, nobody testified that in their opinion, I probably banged my pen on the counter and didn't do any damage. If I took the business end, maybe they'd know. That's an opinion. An act is something you do. 5 times. The word facts, F-A-C-T-S, is in the jury instructions at least 13 times. Now, not counting the verdict forms, the jury instructions are 26 pages long. That means once every other page. Facts. And then most notably, the word conduct. Go back. What is a fact? Well, the judge has an instruction on what constitutes evidence. You're defining facts. But a fact is something that you cannot ignore. Facts are things that exist, you know it, and there's no doubt about it. That's what it is in a criminal case. When you reach a conclusion, 12 of you, that one thing happened, and you all agree that that happened, and there's no doubt in your mind, that's a fact. But that word is used 13 times or more. The word conduct. Conduct is used more than 30 times. What is conduct? It's not an opinion. It's things you are doing. When you go sing karaoke at the local tavern on a Tuesday night or bowl on a Thursday, your conduct is your physical activity. So between those words, there is a reference 48 or more times to the question you can't answer in this case. What did they do? Not what does somebody guess they did, not what does somebody think they did, not what they could have done, but what did they do? In the modern world, we have this wonderful thing called the internet. You're not supposed to look at it on this case, but I'm allowed to, and I went back and I listened to the prosecutor's opening statement. In my 40 plus years doing this work, I know I don't look anywhere a day over 66, I understand. In 40 years of doing this work, I was a prosecutor for a number of years, I was a defense attorney for the last 30. And I always ask myself, what is my theory of the case? What facts exist and what do they show about the law? When I'm defending a case, well, let's take a simple shooting case. If I'm representing somebody who's accused of shooting another person, as Dr. Christensen noted, just because you're leaking, you have 3 holes in you, doesn't mean we know a crime occurred, but we know bullets apparently penetrated if we find bullet holes and we remove them. The bullets, they're there. So those are facts, that's conduct, somebody pulled the trigger. He said, maybe you shot yourself, maybe you were shot accidentally, maybe you were shot intentionally. It doesn't answer the crime question, but at least there's some facts you can discern. And then you get into questions of, was it self-defense, was he aiming at you? Then you get these scientists who talk about the angle of entry, the penetration, stippling marks, all this scientific stuff that helps understand what happened. That's when you have things that you know happen. But I listened to Mr. Allen's opening over the weekend again. It wasn't very long. And you know what else it wasn't? Factual. He gave no facts. He gave no facts about how my client and her mother worked together to kill this girl. Now, so as a defense attorney, I spend the entire part of this trial saying, what is the prosecutor going to tell the jury about how she died, other than opinions? Because the opinions are, well, there's 2 sides to every story. The opinions are split. You give whatever weight you want, but the instruction tells you. You can't decide, and you can't decide. But in terms of what happened, there was nothing in opening, which is not evidence, about how it happened, so I'm still struggling all week with that. What is he going to say? I listened with great attention to Dr. Steer, who, the transcript shows some of his answers went on for 4 pages. He certainly seemed to be entertained by entertaining you folks, but really, he was guessing about what happened, and a lot of things he said he admitted were not things he could know. So, today in the initial close of the state, I heard the prosecutor, for the first time since the morning of the 28th of April, seems like just yesterday, he actually gave some facts, and I wrote them down. At 9:50 this morning, he talked about holding one's hand over the lips. There's no evidence that anybody did that. That's a speculation. That's the guesswork, the jury instructions, and the prosecutor told you not to engage in. And then he said it was the manual application of force to the mouth. I didn't hear anybody talking about any other injuries around that area from the medical witnesses on any side, so if that was something Mr. Allen had evidence that it happened, why didn't he present it to Dr. Steer and Dr. Christensen and Nurse Tristan Bristow? He then gave us a second factual claim. At 9:50 again, closer to 9:52. He said Lori and Alexis held her down and suffocated her. There's no testimony that happened. There's no evidence that allows even an opinion form you to conclude that two people did that. But remember, I represent the bat lady. I'm sorry, I represent the raccoon lady. She works as an arborist. They go up in trees every day. Raccoons live in trees. Baby raccoons live in nests. Ladies and gentlemen, my wife and I are very avid flower gardeners, and I can tell you this, that I would send the children inside when I discovered bunny nests. Because there were things that needed to be done that needed to be done. Most people have no problem eliminating pestilence in the form of furry critters if you have to do it. If you've got an infestation of raccoons or rabbits under your porch or your deck or in your garden, and you want to have a garden or a deck without the smell of a dead body underneath, you kind of sanitize it, you kill them. You do it in ways most painless way. You try to be kind. In the same way you do if you shoot an arrow into a deer and it doesn't go down. You need to put it out of its misery. The raccoon lady saved, you heard it, hundreds of baby raccoons over the last 10 years. That is who she is. I hate raccoons. They stole my tasty cake when I was camping as a kid. But she loved them because they were alive. She loved them in the same way, instinctively, that she loves all of life, as you saw. And the prosecutor says that the raccoon baby saver, the person who gets up early to make formula for raccoons, I know you can't get baby formula right now, but you can still make raccoon formula. She would suddenly walk in and suffocate this poor, struggling little girl. Now, I made another tally. The tally was how many times the prosecutor used a particular phrase. Common sense. Somewhere around 9 or 10 in a 21-minute closing argument. That's every other minute. When a prosecutor is asking you to apply your common sense, they're asking you to leap to a conclusion that they can't prove from evidence. When he gets up again and talks about common sense again, remember he's saying, common sense says this is what happens. Common sense is wrong. I'm going to prove it right now. I have a famous picture here. Can you see it? Maybe some of you have seen it. Who here in this picture sees an old woman? Raise your hand. 1, 2, 3, 6. Now, let me just turn away for a minute. I'm going to cover something. How many people see a young woman? Okay, did I change anything in the picture? No. When you look at this, common sense isn't really what's at work. It's what you see. In the same way that Tristan Riston said, if somebody comes in and has a stomach ache, and you don't pay attention to the big picture, but just the stomach ache, you see a beautiful woman. And what if the rest of the story is a heart attack and you miss the signs? Common sense is an appeal to snap judgments. They're not allowed in here. So every time you think of the distinctions between any of Steer's opinions that you find reliable in his 43 minutes of autopsy versus 30 or 40 hours that Dr. Christensen spent studying that record and thinking it over and consulting. Every time you hear something, you think, okay, well, that's what he saw. But did he go back and see it? And one little footnote. If he's not an advocate, then why is he in his paperwork before he comes in here telling you know what, I see more now? Well, where was that 4 years ago? You weren't paying attention 4 years ago. Now you're looking for what? Support for the prosecution. That's what it was. Now, what we see at first glance is not always what we see. That's common sense, and yet common sense causes us to make a snap judgment about something. And it's really easy. Here, I'll make the prosecutor's argument for you. These people were charged with responsibility for this girl. 2 women were present. This girl shouldn't have died. She died. It's their fault. That's it. Common sense tells you it's their fault. That's it. Just vote now. You don't have to leave the box. That's it. That's not what you have to do. So I go back to that instruction. You're the sole judges of the facts. If you cannot determine what either Alexis, the raccoon lady, or her mother, Samuel's mother, if you can't determine what they did, then you have a real problem. Remember I started with the jury instructions? I'm going to finish with some other things, but and I did say 11:30, and I'm going to finish right around there. The bailiff, I'll check a little bit. Here's what you have to do. The word conduct is part of the analysis of a crime. And I'm just going to go through on page 6 of the instructions under the, I'm sorry, go back to page 3. On page 3, we have the first elements of the crime that the state must prove. Okay, cause, the defendant caused the death. Cause meaning the defendant's act was a substantial factor. Well, stop right there. How do you answer that question if you don't know what one or the other defendant did? And you don't. You can only guess based on opinion. You can only, no, the judge will tell you, the DA will tell you. You're allowed to listen to the medical opinions and rely upon them, but can you rely upon them to the point that you know what the act was? No. Because they can't tell you what the act was. There were no handprints on the face. There were no pillows with saliva. Nothing. It's guess. So, next, the defendant caused death by criminally reckless conduct. What do you have to do? Well, you have to determine if the conduct created a risk of death or great bodily harm. How do you do that if you don't know what the conduct is? Next, you have to decide that one or the other of the defendants, Lori or Alexis, was aware that their conduct created a risk of death. Well, if you don't know what their conduct was, how can you gauge whether they should have known? Remember, discussion in the opening statement about carelessness, recklessness, and intent. Recklessness is, I don't give a darn what happens. Well, what was Lori, what was Alexis doing? You don't know. That's why the word conduct is in here more than 30 times, because you need to know the conduct, and nobody has been able to present it to you. The only conduct described came repeatedly from the Barrys, and counsel plowed that row. I'm not going to do it again, but you get it. This is what happened. Most devious, most extensive, most well thought out, well planned, stupid story of all time. Now, it goes on. In an utter disregard, the word conduct is used 5 times. Well, how do you evaluate that element if you haven't first decided what the conduct was? You can go through and you can see how many times it's in here, but the bottom line is, and this crime's tracked with the exception of one element. So, your first task, as I said in opening, is going to be to decide whether or not you know what happened. And if you can't go on. You can't get to the question of whether the conduct should have left Alexis or Lori knowing she might die from it, because you don't know what the conduct is. You only know that Steer says, well, I believe it was homicidal suffocation, and I'm good at this. As I go through the trial, I make a number of notes about things that might be useful, not to create doubt, but to help you answer the question, what are the facts? And so I make those notes and I winnow them down, and I ultimately toss most of them away. One of the notes I made was that in order to determine the facts, you have to know the conduct, and if you don't know it, you can't conclude it. If you want to rely upon opinion beyond reasonable doubt, well, we at least ought to have a doctor who believes it beyond reasonable doubt what happened. And if he can't tell you what happened, if he can only say, I believe this is the ultimate outcome, this is the term I use, he's an advocate, he's not a witness, then you can rely. 51% sure is great. If you want to win an argument, after a few drinks on Mother's Day, that doesn't work in this book. Sometimes I sat here this week and I said, I think I figured out the state's argument. The butler did it and the parliament did it all. That's as far as the facts could get from me all week long. So in some of these notes, I know some things, but I want to talk about something I started with. So this case is about the mystery of life and the mystery of death. It's really about it. And therefore, we are sitting today, in this case, at the intersection of faith and facts. Those of you who are faithful people, Catholic, I know what a rosary is, I have one, it probably should be more worn than it is, but we talk about the mysteries of the rosary, the sorrowful mysteries, the joyful mysteries. See, I can't remember this. I'll think of it. What is a mystery? A mystery is something you take on faith. In faith. Why am I talking about faith? We have two very faith-filled families here. And they understand the concept of a mystery. A mystery is you suspend logic and you take it on faith. Faith and facts collide. You don't have to subscribe to any religion. You don't have to like that I've talked about religion to understand that there are things that people just want to believe because they want to believe them, but in this courtroom, in this proceeding, on the most grave charge, homicide, you have to get settled on the facts. You can't have faith that the doctor is right. You have to see that he was based on the facts you think his opinion is based on. So what I ask you to do is think about this. If there is, as Dr. Christensen noted, and even as Steer admitted, room to disagree in science. What does that mean? It means that the people who thought the world was flat and sailed it were wrong, but they believed they were right. They were scientists, I guess. They were explorers. In the same way, if you have two qualified, let's just give Steer all the credit in the world. 5,000 autopsies, you can do them with your eyes closed, and one hand tied behind your back, like radio hosts used to say. But the bottom line is, if you have a disagreement, what that's telling you is science doesn't answer the mystery, and it can. It sometimes cannot. The mystery can remain the same way the mystery of life has never been figured out. We can prolong life, we can engender it from stem cells and in vitro fertilization, but we can't create life, no one's done that. So the mystery remains. Even Lisa Cady admitted on the stand that she doesn't know why her daughter died. Lori, Alexis, Mr. Cady, they don't know. Nobody knows. So if you can't solve, the jury system in the criminal courtroom is not designed to solve mysteries. It's designed to see if you can figure it out. I think it's 11:27 by the digital clock and 11:29 Hallmark. So if you'll indulge me with the digital clock, I'll finish at 11:30. Some of you might have thought, listen, I'll tell you what I don't want to do. I don't want to have a heart attack in Mineral Point anytime soon. Because I don't want Simmons called to the scene. He's not going to be happy. I was a little mean to him, and I apologize if that offended you. But what I want to point out is that what he did was make the snap judgment that you made when you looked at that picture. That's what he did. And there's no place for that in this courtroom. He got out of his lane. His lane was And he's done this for 20 years. He's tried to save lives, and that's commendable. Nothing I asked him communicated that I understood that, but I do. But what bothered anyone listening was that he wanted to make a snap judgment, like on the old lady, young lady picture. And that had no place in this, and he dismissed information as a result. That was where this started. It didn't taint necessarily what came, but it certainly illustrates what you can't do. There's a lot of things your verdict can't do. I'm going to go through them just so you're clear. If the prosecutor, some prosecutors get up in their final argument and ask for justice for the deceased. Guess what? That's not in the jury instructions. That's not your job. This is not your verdict, whether it's guilty or not proven beyond a reasonable doubt as to the defendant, does not declare one side a winner and one side a loser. It does not bring back to life a girl who will always live on in memory. Those who have lost a child among us understand that that's always a minute ago. It never goes away. This case won't fix it. This case will not relieve the pain that you saw on the stand from two ladies who care deeply and whose heart the cadence knew. Their hearts didn't change. Their pain will always remain. A child died in their care. Nothing in your verdict can do that, and nothing in your verdict is going to say to one side or the other, you win and you lose, because they're all losers here. And that's unfortunately, or maybe fortunately in this case, where faith comes in. Now, you heard about an inquest. An inquest is an effort to try to find out whether or not the crime occurred in a death. But the inquest was very one-sided, and this trial was two-sided. So there's something potentially really, really, really deeply moving and helpful about having both families have sat in here for the first time since the day everyone lost the girl they loved. Everyone's heard every possible explanation or examination of why. And you can shake your head at the sky all day long and say, why me, God? Why my God? But they've at least heard that as of today, no stone has been left unturned. So perhaps for them it will be cathartic. Perhaps it won't. It'll never relieve the pain, but at least there's been a full and complete explanation from all corners of what may have happened. And the answer is, nobody really knows. Remember that. That could be something good that comes out of it. Your verdict is not intended to do that, but it could. I'm going to give you, it says 11:30:59, so I didn't lie. I misjudged. One last thing I want to talk about. Nobody in a jury is given an instruction as to how you deliberate, other than pick a foreman, hear each other. So I would ask two things. When you go in there, there's a real common tendency among jurors. At 67, I've studied this stuff independent of my own. People want to go and say, well, why don't we take a vote and see where we stand? Please don't do that, because it causes divisions immediately. Don't vote. Pick a foreman, pick a presiding jury, but don't vote. Please don't vote. Second, when you do vote, only do it after you've talked over all of the evidence on each of the crimes as to each of the accused people. Why? Because if you start out with a vote and you see, oh, it's 8-4, one way or the other, we can't even ask you numbers, we don't know. Then the people in the 4 feel a little cornered and a little trapped.
I would object to counsel instructing the jury on how to deliberate. That's entirely their choice.
I'm allowed to give them suggestions, Judge. There's nothing in the law that says I can't. I mean, this is closing argument. I'm asking them to consider the psychological impact of if they vote early versus vote late. I think that's
That's your suggestion. Overruled, go ahead.
Thank you. Take your time. Fully deliberate before you vote. Then when you vote, vote in secret. Don't do the show of hands like I did here. Don't put pressure on us. Just like in the movie 12 Angry Men, where they take a vote and they all see who's holding them up from the ball game. Don't do that. Vote secret. I'm not going to ask you to search for that. I'm going to ask you to search for the facts and protect your deliberations in the ways I suggested.
the state has a chance now to do a rebuttal, and then I've got about 5 minutes more of instruction. Mr. Allen?
Take a short break.
Yes, does the jury mind if we take, let's say, a 15-minute break, come back, and then finish up, and that'll go past the lunch hour, but it should be fairly quick.
I don't think I'll be terribly long.
All right, if the jury's in favor of that, please raise your hand so I know. All right, good. All right, we'll take a 15-minute break. Everybody is to be back here by 10:02, and that means 10:02. All right. All right, we're going to keep the jury past when they usually have a break for lunch. So when I say be back here at 10:02, I mean everybody in their seats at 10:02. All right, we're recessed.
hear that voice and find the defendants guilty of first-degree reckless homicide. If you find that the actions of Lori and Alexis somehow negate the utter disregard element of the charge, despite the overwhelming evidence of what was done to Selah, then I would ask you to, at minimum, find beyond reasonable doubt that Lori and Alexis Berry are guilty of second-degree homicide in causing the death of Selah Kagan by their criminally reckless conduct. Thank you.
I'll continue with the instructions. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of these cases is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether each defendant is guilty or not guilty of the offenses charged. Any consequence of your verdict are matters for the court alone to decide and must not affect your deliberations. The following three forms of verdict will be submitted to you concerning the charges against each of the defendants. One reading, we the jury find the defendant as named in the verdict guilty of first-degree reckless homicide as a party to a crime in violation of section 940.02 sub 1 of the Criminal Code of Wisconsin at the time and place as charged in the information. Another reading, we the jury find the defendant as named in the verdict guilty of second-degree reckless homicide as a party to a crime in violation of section 940.06 of the Criminal Code of Wisconsin. And a third reading, we the jury find the defendant as named in the verdict not guilty. It is for you to determine which one of the forms of verdict submitted for each defendant you will bring in as your verdict regarding that defendant. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at the verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with that verdict. Jury deliberations are to be conducted with 12 jurors, and it is now time to select 2 of the presiding sitting 14 jurors to become alternates. The jury was advised of this fact at the beginning of the voir dire process. The clerk shall randomly select 2 jurors' names by use of the tumbler. The clerk will read these 2 names who will become alternate jurors. After the alternate jurors' names are read, those jurors will stand and be taken to an alternate secure location to remain there through deliberations. The alternate jurors are not to deliberate amongst themselves. I think what I would like is for the alternate jurors to remain in the courtroom so that I can give you instruction if you want to go home and get a book and come back here. I would like to give you instruction that you're not to discuss this matter with anybody. But the alternate jurors will need to remain through the deliberations in case they are needed. All right, Madam Clerk?
Just for verification, I do want to show you how two names are in.
Yes, they are. All 14 names are in the tumbler.
Amy Hugel, raise your right hand. Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direct of the court, until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or their verdict they have agreed upon, so help you God?
All right, I'm giving Exhibit 58 to Mr. Rosing, the bailiff, and the jurors are excused to deliberate. All rise.
I think it's certain.